Добрий вечір, це програма «Перша студія». Сьогодні у нас в гостях незвичайний гість. Це професор Ханс Петер Гравер, професор права, який досліджував те, яким чином змінювалась судова система, яким чином працювали судді в країнах, які пройшли через революцію або дуже серйозні зміни, як, наприклад, Німеччина після Другої світової війни чи інші держави. Ми сподіваємося, що наша країна теж буде під увагою пана Гравера, і він приїхав сюди в тому числі на запрошення програми «Справедливе правосуддя» поговорити з українськими суддями, з українськими правниками щодо того, як насправді ставитися до судової реформи, яку ми всі хочемо, якої ми всі очікуємо, але ми до кінця не знаємо, що ми можемо отримати. Чи можемо ми змінити всіх суддів за один день? Саме про це ми будемо говорити з паном Гравером, будемо говорити англійською мовою. Hello.
Hello.
Mr. Graver, the first question is the must-ask question for every Ukrainian, I would say for every Ukrainian. Can we change the legal system and all the judges in one short period of time to have a proper democracy fast?
I think that is very difficult. Because I think in order to understand how judges and the judiciary functions, you have to go back to the legal tradition and the social history. Experience shows that the judicial system and the legal system changes quite slowly and is quite resistant to change. So it is necessary to do more than just change the laws or the institutions. You also have to change the mind and the mentality of the people, and not only the judges, but also of people in society in general. If people do not trust the judges will not be trustable. So you have to change both the social attitude and the judges at the same time.
But from your experience, because you've seen this many times, how can you trust the judges of the system that was obviously doing harm to the people, that was obviously making harmful decisions, unlegal decisions, as we've seen that during Orange Revolution and during last Revolution of Dignity? How do you raise that trust?
Well, you know, we want our judges to protect us if the state starts to repress the people. That is one of the obligations of the judiciary, is to protect people's individual rights and to control the executive and the state power. Unfortunately, experience shows in many historical instances, not only Ukraine and the experiences you have in this country, but in all countries more or less, that when the rulers become authoritarian and start repressing the population, the judges become instruments of oppression. We have seen that also in well-established democracies in the Western world. For example, Germany in 1933, where the judges instantly became an instrument of oppression in the hands of the Nazis. And the same happened in South Africa when the apartheid rulers came in 1949, and it happened in the Latin American countries like Chile, for example, which had one of the best established judicial systems of Latin America. When Pinochet came to power, they stopped controlling the state authority instantly. So this is a general problem, I'm afraid.
Why judges do not stand to that change? Why judges still obey to the rules that they should protect by heart?
That is a very good question, and I think one needs to understand the role of the judge to come to the answer of that question. Because on the one hand, we expect the judge to protect the rule of law and to protect individual rights and to control government. On the other hand, it is also an expectation that the judge applies the law as it is given. And the law is given by the legislature and the executive according to a set of rules in the Constitution. Now, if there is a coup or a revolution, judges very quickly adapt to the new people in power, and they stick to their judicial role of applying the law. In many cases, in most normal cases, this does not pose a problem because the law will respect the rule of law, so to say. And there may be some instances where there is conflict, and the judges can correct this. But in cases where there is a deep contradiction between, on the one hand, protecting individual rights, and on the other hand, upholding the law, the judge is facing inherently conflicting demands, which are impossible to resolve in a way which takes both expectations into account. And I think the judge then often feels himself or feels herself in the position where they say, I have to stick to the role of a judge. I cannot substitute the law for my own opinions on what I think is just and what I think is fair, because that would be to go outside of the role of the judge and to act as an individual person. So I think this is basically the difficult issue, and the judge then, when the matters become too difficult, say, well, I'm only applying the law, and so don't blame me, blame the evil legislators or the evil executives.
So basically, it is not the judges who can imply the democracy, it's not the government who can apply the democracy to the country, it's the people that need this or that system, and judges. It's only a way to keep it rolling, is it?
Well, I think judges should be a line of defense of the people against this development in government. And I think that there are things we can do to learn from the historical experiences to put the judiciary in a position to be more of a defense than we have seen. And these things are things like training the judges more in the rule of law and making sure that these values are deeply set in the mentality of the judges. But this is not enough. We saw that, for example, in Germany, because the German judges were deeply trained and set in the rule of law. So we need more. I think we also need training of the judges to prepare themselves for this type of conflict, so that when it does arise, they already have gone through some training and they have some experience in how to deal with it, so that they see there are other alternative answers than just applying the law. But it's a long-term process. And I also think that it's important that the population of a country understands the value of the rule of law, because often authoritarian rulers have populist support. They manage to mobilize support because they talk about an outside enemy or threat, or in a society they try to use splits in society between different sets of the population and so on. And it's quite easy, what we see from historical experiences, to mobilize support for authoritarian measures. This can only be countered also by educating the people in the value of the rule of law.
Can judges be populists? Can judges make a decision because people want it? We have many times we have crowds of people in front of the court demanding the things that they believe are right. Can judges listen to those people?
Well, judges are people too, of course. So to the same extent that other people are moved by populist streams, judges can also be that. But it should be part of the training of the judge to resist all outside influence. And populist demands is one type of outside influence that the judge should be trained in resisting. On the other hand, of course, you know that the law should not develop in a way to become very far removed from the general legal feeling of the population. So this is very complicated to balance between not obeying or following populist streams and, on the other hand, applying and developing the law in a way that is recognized in society.
Well, it's your book says that in most of the times when we speak of Germany or other countries, after Nazis or other autocratic regimes fall, judges were not forgiven, but they stayed, and everybody stayed. Why do you think, even in Nazi times, why people were okay with this system?
Yeah, that's a good question, and experience shows that judges are almost never brought to account for their contribution to authoritarian regimes. But now, before we go into that, we must remember that in most cases, when a country comes out of an authoritarian state, there is no great criminalization of the previous rulers. In most countries, there is a period where people demand revenge and so on, and this goes over, and there is a reconciliation. So it's not typical that one punishes authoritarian rulers. But it's even less typical to punish judges. And I think one has to look at each case for itself. Germany is one experience which is complicated because at that time the Nazi ideology and the support of the Nazi regime was so deep in the German population that if you wanted to punish or to evict everyone who had been complicit in this, you would have almost more than half of the population would have been made guilty. So you had to draw a line, and I think it was very difficult in the German situation to start a campaign to clean out the judges who were most responsible, because I think what the Federal Republic at that time most needed was to establish a judiciary that would be loyal to the new constitution and to the rule of law. And it was difficult to achieve this and at the same time have the judiciary feel that they were subject to a situation where sanctions could apply to people in an unpredictable way. So I think that was one reason that it was better than to let the judges be and to have them as loyal followers of the new constitution.
But what can we learn from Germany that was divided to the two pieces? And in Western Germany, more or less, more people stayed on their positions, while in the Eastern Germany, Soviet rulers changed much more people. What approach was more successful in your in your opinion?
Well, from the point of view of rule of law, I think the Western approach was much more successful because the Soviet conception of rule of law is very different from the Western legal tradition. So what they did in the eastern part of Germany was that they got rid of all lawyers and they started a totally new legal education on scratch. So they sort of turned back and they educated them in the socialist ideology. But I think that they then created a legal system where the judges were more bureaucrats than independent judges. So, of course, they were successful seen from their own aims, but from the point of view of rule of law, they managed to destroy what was left of rule of law in the East German state.
You're a big supporter of the Western approach to the judicial system. Can it be imported? Can we change the system other way from post-Soviet to the Western approach, which is different, which based on different principles?
I think it can, and I'm not in general sort of a supporter of the Western system as such, but there are elements of the rule of law which I strongly support, and that is the clear division of powers between the legislative, executive and judicial branch, and also the submission of the executive branch and the legislative branch to law. So everyone has to follow the law, even the rulers. And this is a part of the legal tradition of the West which goes back to the conflict between the Pope and the Emperor in the 11th century, where they had the debate on who should have the right to appoint bishops. And there was a compromise which entailed that also the worldly rulers were subject to law, and that the individuals, the citizens of the states, had a right to have their rights determined by independent courts. Now, this has not always been followed, of course, in the history of Western Europe, but it has been part of this legal ideology, which we call the rule of law. And I think for a state to function, or a society to function as a democracy, you need this conception of law, that also the legislator and the executive are bound by the law. They have to adhere to some legal rules. They cannot arbitrarily determine what measures they want to use. And whether they are within the law or not is determined by independent courts.
But again, do you know from the history the ways that someone from outside applied that system to other country? Like I know that in the Singapore there were attempts to take British lawyers to work there. We do have ministers from abroad that work here quite efficiently. Is it possible to have lawyers from other country who support the country and who make a push for the system?
I think it is possible, and one has historical examples. Singapore, you mentioned, is one. Japan is also a country which has successfully implemented this conception in their otherwise very different system from the European and different traditions. But I think the essential thing is that the population and the politicians have to understand the value of this. Because if the population expects the judges to be servants of the executive, to follow orders from, for example, the president's office or from the prosecutor, if that is the general expectation, it is very difficult for the judges to be the only ones with a different expectation and to establish a rule of law. So this really needs to come into society as a demand and a need that the people have, and an expectation that people have.
So I mean, only the conflict between different powers, like between society and the governments, will establish the truly independent court in Ukraine. Like for example, in Ukraine, is there a way to establish truly independent court? We never had an independent court, to be honest. Do you see the way to establish that? Do we have to go back to 11th century to learn the experience?
I don't think so, and I think that the people of Ukraine, at least people I've talked to, they understand this well now. So I think that it's a matter of working systematically and also working with not only the judges and the judiciary, but working with the surrounding factors of the judicial system, like the administration and the prosecution, so that everyone understands the need of an independent judiciary, even if the judges take decisions which people disagree with. I mean, one has to also, because that's the other side of it, an independent judiciary, is that sometimes the executive or the politicians or the population disagree with the decision the judge has made. And then they must see that this is part of the game, that when the judges are independent, it means that they also sometimes take unpopular decisions, but that should be respected.
Another thing you've mentioned when we talked to Asian countries like Singapore, there is one thing you haven't basically mentioned in previous times, is the corruption. Because the corruption is something that makes Ukraine different from any European country, and it's highly highly in the gene of the people to perceive judges as corrupt people, and we know why. How to get rid of this simultaneously with other problems, or it's just another problem that should be decided in a different way?
Corruption, I think, is one of the worst illnesses of a society if it is abundant in the society. But also there, I think one has to work not only with the officials that are being corrupted, but also with the expectation and the actions of those who corrupt the officials. There are always two parties to corruption. It's the one who's corrupted and the one that is corrupting. And if people expect public servants to be corrupt and offer bribes in situations, then many more public servants are subject to bribes than if the situation is different. So I think also this is a cultural and social issue, but it's also, of course, a legal issue and a criminal issue. And I think that the way many societies have gone to be able to rise out of a situation of corruption is to have independent agencies that investigate into and follow up instances of corruption, so that this is not controlled by institutions that are already corrupt.
But how can you know that those institutions will not oppress judges, will not tell them to make decisions they need?
Well, if you have independent institutions whose only goal is to investigate corruption, they will have no reason to try and influence judges in other instances. But if you have this as a part of the prosecutor or as a part of the executive, then of course you have a situation where the information that this agency gathers can be misused for other purposes. So that's another reason why I think it's necessary to have this independent of other organs of the state.
That took us to the other question: how protected should be the judge? How protected should be his life, his private life? Should be open to any people. A place where he lives. There was a huge scandal a couple of years ago when the legislation that was intended to protect judges was perceived as something that will protect judges that are taking people to the custody. How, in a legal way, where's the balance between protection of the judge and being transparent?
Well, transparency is very important to establish trust in any institution. So I think achieving transparency in the functions of the judiciary is essential. So court hearings should be open to the public. Judges should give reasons that are published for all decisions they make, and these things. So this should be public. Whether you should make public the home addresses of the judge, I think that depends on society. If the social conditions are such that the judge is under the threat of being influenced or manipulated or threatened by forces in society, it may be necessary that one protects the judges from this. I don't know about the conditions here, whether how it is there, but in some societies, of course, at some points, it is necessary to protect the judges in this way. But in their public functions, there should be full transparency. And when it comes to protection of the judge against repression by the state, criminal responsibility and disciplinary responsibility, I think that, again, the judge should be protected only in his function. So the judge should have no immunity for other things. If the judge drinks and drives or beats his wife or whatever, he should have the same responsibility as any other citizen, and there should be no bars on investigating and applying sanctions for such things. When it comes to the judge's function as a judge, I think that the responsibility should be limited to only certain instances. One should not punish a judge for giving a ruling which somebody disagrees with, even if it is a wrong ruling determined from the point of view of the law or the facts of the case. But if the judge is guilty of corruption, he should have no protection. If the judge is guilty of taking instructions from others, for example, the executive, he should have no protection. And if the judge is engaged in gross violation of individual rights, he should also have no protection. But apart from that, a judge should not be made criminal or disciplinary responsible for his rulings.
Have you looked at the change to the work of the judges and to his communication with people and ties with people after the new technology revolution? Is there a change where everyone is in the social network, everyone can see, anyone can blame judge in the social network, making a pressure on them? How that will change people and the judicial system? What do you think?
Well, the new communication society has definitely had many changes, and it's first of all, it has made judicial decisions more available to the public, which is a good thing. It's a good thing for us who study these things, and it's a good thing for the public. When it comes to social networking, I think that this should become part of the training of the judge, to prepare the judge for this. A judge should be quite reserved, in my opinion, in expressing opinions on social networks. A judge should not comment on legal proceedings and his or her own rulings. But I know that there are judges, even in my country, who are on Facebook and who use that, mainly for private things, of course, but also for some more issues of legal policy that they raise. And this is a natural development when the younger generations enter into the judiciary, who are well familiar with social network. Of course, it's natural for them to also continue with this when they enter into functions of judges. So these are things that we have to go through a learning process in society to adapt to these new situations.
Going further on that question, do you believe that judges can change something in globalization? I mean, do you believe in truly independent and effective international courts that can solve the questions like Russia aggressing on the neighboring countries, or Syria, or other hotspots on the planet, where that are expecting something that can be said by some high international court, but we've never seen really international effective courts so far?
No, that's a very long way ahead, I think. It can be perhaps a dream to some, perhaps a nightmare to some, I don't know, but I think that as the situation is today, I don't believe in that. The international law is governed too much also by power and dominance. And you see, for example, there was established an international criminal court to hold state rulers accountable for crimes against humanity and genocide and war crimes.
Yeah, but mostly they're accountable if they lost a war,
yes,
like Yugoslavia.
Yes, and even also a big country like the US has refused to recognize this. So this just shows the state today. I think one experience we can learn from is the EU, where you have the development not only of courts, but you have a development of tighter and tighter cooperation between independent states based on law. And there you see that the European Court of Justice may have some influence also on these issues in countries. But it's difficult. If you look at countries and the development in, for example, Hungary and Poland, you see that even within the EU, when there are developments in a particular country, it's difficult also to subject this to international or supranational, as we call them in the EU courts. So I think it's a very, very long way ahead. And there are also issues that need to be discussed politically between the relationship between national law and national courts and international law and international courts. This also goes into questions of democracy and who is to determine the development of the laws in a country. Is it the people of the country? Is it courts? Is it the national courts or international courts? You know, I come from a country, Norway, who's chosen to stand outside of the EU, also because of such issues. These are very much debated in my country, and I know they are debated also in the EU countries. And they are difficult issues, and where there are no, I think, clear and set answers.
Can I ask you for advice? We had a story about people protesting against previous President Yanukovych on wheels. They were driving around his mansion, and demanding him to talk with the people to be more responsible. Hundreds, if not thousands, people were, according to the legislation system, according to the judge decision, their driving licenses were suspended, and there were criminal cases against them without any proofs, just because they were seen or spotted around Yanukovych mansion. Some of that judges still work, and it is absolutely obvious, and it was for anyone that were illegal decisions. But they still work. Some of them still work. Some of my friends were harmed. If they will see those judges on the street, what should we do?
Well, again, this brings us back to where we started, doesn't it? With the role of the judge in authoritarian settings. And I think one has then to answer this question from two perspectives. One is the perspective of theory. How should one, sort of based on concepts of rule of law, deal with this? And the other is the pragmatic question. What is the right or the wise thing to do in a country like Ukraine under the present situation? If we take the first aspect from theory, I think that in these cases, the judges were faced with the dilemma which I explained between the rule of law and the demands of the positive law at the time. I think that even if judges in this difficult situation made the wrong decisions, it is not sufficient to hold them accountable today, to fire them or to discipline them. But if the judges made their decisions because they received instructions to decide in a special way, then these judges were committing offences. They were stepping outside of the judicial role, and their decisions were illegitimate, and they should be, or at least could be, sanctioned for that. Also, if the judiciary were engaged in a systematic persecution of political opponents, they were then very close to participating in what is defined as a crime against humanity in the statutes of the International Criminal Court. And they were then seriously infringing upon the basic individual rights of the people who were brought before them. And also this they could be held accountable for. So under these, I don't know the specific circumstances of what was taking place, but if there were instructions and judges were acting under instructions, or if this was part of a systematic persecution, one could hold these judges responsible. Of course, after having proceedings respecting the rule of law with the presumption of innocence and burden of proof and everything. Now,
so you have to go for the legal decision?
Yes, well, because also, I mean, even criminal judges are entitled to the rights of a criminal in a criminal trial. You cannot say that you have a different standard than you have when you accuse a murderer in a normal criminal trial. So that is the theoretical. Now it comes to the practical. I think that a basic challenge facing Ukraine today is to establish trust and confidence in the judiciary and to make the judiciary and the judges function under the conditions of the rule of law. So the basic aim must be to establish and re-establish the trust in the judiciary. And for this, you need judges who are honest and who protect their independent status. So on the one hand, to achieve this, you need to satisfy the public that the judges can be trusted. And this may entail that you must remove some judges who have been guilty of crimes during this time. On the other hand, if you do this in a way that make the judges in general fearful of sanctions if they reach decisions that are unpopular, you will not achieve the aim of having an independent judiciary, because the judges will be afraid, and a judge who is afraid will take his decisions out of fear and not out of the law and the rule of law. So that's a dilemma. So it may be like in Germany that the best thing to do in the long run is to look forward and not so much backwards.
Thank you, Professor. Дуже дякую. Це була дещо теоретична розмова, яка надзвичайно важлива для кожного з нас, для всіх, хто хоче трошки іншої країни, трошки інших суддів, яка означає, що ми маємо вимагати не тільки у них, але й у себе, у влади і навколишніх. Дякую. До побачення.